A foreign element is anything which is not domestic and has a foreign component to it. It can be a foreigner, a foreign corporation, an incident happening in a foreign country, or a foreign law chosen by the parties. Without a foreign element, the case is only a domestic problem. The presence of foreign element in a case determines the existence of conflict of laws situation. Where there is no foreign element, no conflict of laws exists.
I'm going to discuss the three phases of conflict of laws. First, the jurisdiction. It is the power of the state to affect persons, property, and circumstances within its territory. There are three types of jurisdiction. First, the jurisdiction over the person is the authority of the court to render a decision that will bind the parties to a suit. The court may acquire a jurisdiction over the plaintiff the moment he institutes a complaint, and as to the defendant, by voluntary appearance or submission to the jurisdiction of the court. Second type is jurisdiction over the rest, means that it is the jurisdiction over the particular subject matter in controversy, and the basis of the exercises of this jurisdiction is the presence of the property within the territorial jurisdiction of the forum. It may be in rem, quasi in rem, and in personam. The third type is jurisdiction over the subject matter. It is the authority of the court to hear and determine cases, and it is conferred by law. The next phase of conflict of law is the choice of law. That there are three instances when the forum or internal law has to apply in deciding the cases in conflict of laws. So first instance is when the law of the forum expressly so provides in its conflict rule. It is the provision of law which govern the court which laws to apply in cases of conflict of laws. So we have Article 15 and 217 of the New Civil Code, and Article 1753 are those governing provisions when to apply our internal or domestic law. The second instance is when the proper foreign law has not been pleaded and proved. If it has not been pleaded and proven, then we are going to apply our internal law or domestic law in deciding the case of conflict of laws. So the Philippine court will not take judicial notice of the foreign country. But there is an exemption to the rule as provided for in the Rule 129, Section 1 of the Rules of Court. And the last instance is when the case involves any of the exemptions to the applications of the proper foreign law. So these are the exemptions to the applications of proper foreign law.
Foreign non-convenience simply means that the forum is not convenient. It may be that the chosen forum or the place where the suit is filed has no substantial connection to the parties or to the disputed is very inconvenient to litigate the suit in the chosen venue. Also, there are 8 instances where the court may refuse to exercise jurisdiction over the case on the basis of foreign non-convenience. In the case of Bank of America versus CA, the court held that a Philippine court may properly assume jurisdiction over the case if it chooses to do so.
Point of contact. In conflict of laws, the choice of law issues are handled by applying the law of the jurisdiction having the closest link to or contact with the event and parties to the lawsuit and the issues and matters at hand. These are the essential elements of a case, and they are often indicative of a connecting factor or point of contact in the resolution of a case. The Supreme Court in the case of Saudi Arabian Airlines versus Court of Appeals held that in deciding cases, the choice of law is based on the connecting fact or point of contact, such as the following. Number 1, the situs of the rest. Number 2, the place of celebration. Number 3, the place of performance. And number 4, the place of wrongdoing.
Characterization of conflicts of law. Before a choice of applicable law can be made, it is necessary to determine under what category a certain set of facts or rules fall. This determination process is known as characterization, or the doctrine of qualification. It is the process of deciding whether or not the facts relate to the kind of question specified in the conflicts rule. The purpose of characterization is to enable the forum to select the proper law.
In serving summons, you first have to determine whether the defendant is a natural person or a juridical person. In case of a natural person, service of summons may be made by personal, substituted, or extraterritorial service of summons depending if the defendant is a resident of the Philippines or not. In case of juridical persons, the service of summons depends on whether he is a domestic private entity or a foreign private entity with a resident agent or a foreign private entity without a resident agent. The foreign private entity must have transacted or is doing business in the Philippines.
One of the elements in applying the non-foreign convenience rule is the principle of effectiveness. This questions whether or not the court has the power to enforce its judgment or decision. It means that can the court execute the decision within its territory of the party involved in the case. The Manila Hotel Corporation versus NLRC, it held that the Philippine court cannot execute a decision against the Palace Hotel since this corporation is incorporated under the laws of China, and therefore we cannot execute the decision of NLRC against the Palace Hotel.
Theories in the application of foreign law. So there are 5 theories in the application of foreign law. First, theory of comity, so the recognition which one nation allows its territory to the legislative, executive, and judicial acts of another nation, having due regard both to the international duty of convenience. Second, the vested right theory. It is the right once acquired should be enforced regardless of where the suit for its enforcement was filed. And theory of local law. This theory, we apply the foreign law not because it is foreign, but because it is expressly so provided in our laws. The theory of harmony of laws. Under this theory, identical or similar problems should be given identical or similar solution, thus resulting in the harmonies of laws. So the last one, since the purpose of laws, including the conflict of laws, it is the dispensation of justice, the proper foreign law should be applied in order to attain this objective. So that is the theory of justice.